Hi, everybody. Randy Wild here. This is Module 12, Tort Liability for EDL 850 School Law. We're going to be discussing some different cases involving schools, school districts, and school personnel, and negligent cases involving different scenarios from students being injured to abuse to students or supervision. So, hope you enjoy. Tort law comes in two different categories. One is an intentional tort, which would be a more deliberate or violent act committed against a person. This is going to infringe on those person's rights, and usually this comes in the form of assault, battery. It can involve weapons or non involve weapons. The second type is an unintentional tort. This is probably more common in the school setting, I would say. And this is more of an unintentional wrongdoing. And a lot of these cases are going to be kind of classified as negligence, whether it's supervision or whether it's putting students in dangerous situations. That is more of an unintentional tort. So the first case that we'll talk about is Flanagan versus Canton. This involves a fifth grade student in gym class. The way they explained the case was the students were being a little rowdy towards the end of the hour, so the instructor sent them into the locker room to change early. Well, the instructor stayed out in the gym to have a discussion with another student. While he was outside the locker room, some sort of altercation broke out, and a student ended up getting pushed down, hit his head, and sustained some injuries. So the family brought a case against the teacher saying that he was negligent with his supervision. He should have been in the locker room, and this type of thing wouldn't happen. So the teacher ended up finding that, in normal circumstances, if the teacher didn't need to be in the locker room, the students can kind of go through their normal day. They get changed, they come back out, they didn't have any problems. But in this case, because the students were acting up prior to going in the locker room, the court felt that the teacher needed to be in the locker room. And so the family won the case. So the evaluation of this case, some reactive measures, I would make sure that I revisit supervision policies with my staff. I would make sure that they understand the importance of always supervising students. And proactively, the locker room is a hot spot for these types of situations. There's fights that break out in the locker rooms, things get stolen, rumors fly around. And so that's just a place that needs some increased supervision. So just reminding the staff that those things need to go on. And as far as the professional ethics, students were already acting up. So just using your experience as a teacher, and you kind of see that escalated behavior, you probably need to make sure you maybe are in the locker room and have the conversation that he was having, at another time. Wait till after class to talk to that other student and to straighten some of those things out to make sure that kids are in a safe environment in the locker room. The second case is Frame versus Camo. And this involved an eighth grade student, and what they said was a sub teacher. But reading through the case, it was actually an employee, sounded like of the school, but he was subbing for the primary teacher who had to be out of the room. So they were taking a test in the class, and some students were acting up. So the teacher asked the student to leave, and the student kind of showed some defiant behavior, made some loud noises, and when the teacher approached the student stood up. And it said in the court documents he stood up slowly, didn't explain anything about how the student was being aggressive. The teacher grabbed the student by the arm, and subsequently the student then lost balance and fell into the whiteboard. So the family filed assault charges against the teacher, saying that there was no reason for them to put his hands on the student, and that caused their son to fall into the whiteboard. The court found, which I thought was a little strange, that the teacher took reasonable measures. It didn't seem like a situation that would be found necessary to put your hands on a student, but the court did rule in favor of the school and the teacher, saying that there was no assault that happened. So in my evaluation of this case, the reactive measures, I would just want to talk immediately with that teacher that was subbing during the test, and also the main classroom teacher who should have been in there, especially if they were giving some sort of assessment. Um, Proactive measures, I would think about finding some training for my staff. There's de-escalation training. I know my school district requires that everybody take MAB training, which is managing aggressive behavior. Although this student wasn't being aggressive, but it just kind of makes you think a little bit differently about how to approach those situations. Because the professional ethics in this situation is just hands off of students at all time, in my opinion. And this situation, especially, the student wasn't harming or threatening the teacher, wasn't harming or threatening another student. So to me, I just couldn't find a situation where it was necessary for him to put his hands on the student to remove him from the room. There'd be different classroom management techniques that could have been brought forward before needing to grab the student's arm to remove him from the classroom. The third case is Johnson and Johnson versus School District of Milliard. This involved an elementary music class. The teacher was teaching the class a London Bridges game that we all know from growing up, and the students were instructed on how to place another student in between their two arms and rock them back and forth while they sing this song. Well, a student ended up getting rocked back and forth to the point that the two students that were holding him, their grip broke free. He fell into the bookcase, and I'm pretty sure they said he needed around 50 stitches above his eye. There was bone and muscle showing in the cut, so it was a pretty severe trauma to his head. And the family sued the teacher for negligent supervision. They won the case and were awarded some medical expenses. And this case, it was strange that they would teach him that type of game and then not be in the proper proximity. But accidents do happen in the classroom. So my evaluation of this case, the reactive measures, I would want to talk to that teacher immediately just about quality of lessons. And if she absolutely found it necessary to teach that London Bridge activity, then I would assume she would be in some sort of safe proximity during that lesson. Turning around and being at the blackboard, as the parents alleged, the student said multiple times, according to them, to slow down or to stop. They were going too fast. And the teacher claimed that she never heard this. So obviously her proximity wasn't appropriate for the activity. So the proactive measures would just be talking to my staff about being in the right areas during different lessons. A music teacher teaching a physical activity like that should be in the proximity of those younger students. A science teacher doing a lab with chemicals or something like that should be in good proximity to make sure the students are using proper precautions. The professional ethics in this situation, I think, would just be knowing the maturity level of your students. We all know that any age group of students can get rambunctious, but especially elementary kids being turned loose with a somewhat physical game like London Bridge probably needs a little tighter supervision and shouldn't turn your backs and go about your day. If the lesson was that vital, then the teacher probably should have been in a little closer proximity. The fourth case was Hohen versus Manhattan Beach City School District. This involved a student who was attending summer school. The student left summer school early, and they didn't really give a lot of details about how he got out of the building or why he got out of the building. But he was struck by a motorcycle at an intersection and severely injured within proximity of the school. So the family sued, alleging proximity supervision. And, how did the student get out of the school? You can definitely see where the parents were coming from here. And why did the teachers not know that he was out of the school, or why was nobody notified that he left the school? Originally, the court ruled in favor of the school, saying that they were not liable for what happened outside of the school building. And then later, some decisions were handed down from some district courts that discussed that the school was liable for the student leaving the building and them not being aware and them not contacting anybody. So it was kind of a two-headed case. So right away, my reactive measures, sorry, I have a Screencastify popping up, would be to discuss the summer school supervision and attendance policies. I would want to know, how were we supervising these students, and are we keeping track of their attendance like we would on a normal school day? Summer school shouldn't be any different in the fact of the safety of our students.